Hello. I love how your heads all raised in unison. All right, good afternoon, everyone. My name is Lemuria Carter. I am a professor here in the business school and also the deputy dean and head of school. And it is my pleasure to welcome you to today's session where we'll explore AI and the criminal justice system. We have some fabulous presenters with us today. So before I start, I do want to acknowledge the Gadigal people of the Eora Nation and pay my respects to their elders past, present, and emerging. And I have a quote here that I like to share from Terry Jenke, who wrote True Tracks. And I won't read the quote to you, but I think it's really beautiful because she talks about the role that we all have to play in the responsible and ethical use of AI. So as we move through today's discussions, I have no doubt that we'll come back to some of the ethical challenges and opportunities presented. I did want to share this Gartner hype cycle. How many of you have seen this graph before or heard of it? Okay, we have a few hands raised. So Gartner takes a look at emerging technologies, and as new technologies are introduced, there is a lot of hype or a lot of enthusiasm around those technologies and the possibilities associated with them. So you'll see that over time, our expectations peak and then they drop off drastically as we become disillusioned by some of the challenges that we start to learn about as we explore emerging technologies. And then over time, kind of tapers off. So it has things up here related to AI around responsible AI, generative AI, which we've heard a lot about. A lot of topics now around AI deal with large language models. But it will be interesting to see how AI evolves, how it influences how we interact with one another, how we work, how we connect, and how we socialize over time. Also, before we start today, I have to mention that in addition to all of the amazing possibilities for artificial intelligence and some of the societal challenges, there are also environmental challenges as well. So we're going to explore a lot of societal challenges, but I definitely want to note that AI uses a lot of energy, consumes a lot of water, and sometimes disproportionately affects certain areas or regions. And just like there are lots of opportunities to explore the societal morning. We appreciate you being here. This is today's agenda. We are privileged to have this workshop and this project funded by Sydney Southeast Asia Center. And our Deputy Director for SEAC, Sandra Alday, is here. She's going to give us some welcoming remarks. Then we'll have Professor Azrini Wahidin, who will introduce our wonderful speakers today. After that, we will have a panel discussion, and then we'll have a networking reception in the foyer. So I am really thrilled about today's session. Thank you all for coming, and you'll hear more from me shortly. Oh, thank you. Wonderful. Agenda is back. Okay, great. And my clicker is working again. Thank you to our wonderful team in the back, making sure everything goes smoothly and we adapt quickly. We will use Slido. So if you have your phones, please do take out your phones now. Make sure they're on silent. And grab this QR code. So we have people in the room, but we also have lots of our colleagues online. So to ensure we can seamlessly ask questions and engage everyone, we'll use Slido. Slido will allow you to submit your questions and then also vote. If somebody submits a question that you think is really good, you can give it a thumbs up. And as we facilitate Q&A throughout the session, I'll keep my eye on the questions that come in and the votes that they receive. And that's how we'll make sure the session is engaging. If you didn't get this, don't worry. I'll show this again a few times throughout today's workshop. All right. Okay, so with that said, I'm going to invite Sandra to the stage.
Thank you. Thanks so much, Lemuria, and hello everyone. Hello to everyone online. As Lemuria mentioned, my name is Sandra Alday. I am myself a researcher in risk management here at the business school, and simultaneously, I'm also the Deputy Director of Partnerships for the Sydney Southeast Asia Centre, or SEAC for short, here at the University of Sydney. So the SEAC is a proud supporter of this amazingly interesting and really important and very topical research project. So a few words about SEAC, because I think there are people out there who may not know us. So the Sydney Southeast Asia Centre is one of 7 multidisciplinary institutes of the University of Sydney. What does a multidisciplinary institute mean? First of all, it's large because it spans across faculties in the university. Second, their flagship research centers, which means that they're at the forefront of the University of Sydney's research priorities. So SEAC is the only geographically focused research center among the 7 that we have at the University of Sydney. The rest are thematically focused. So we've got the Brain and Mind, amazing Brain and Mind Institute, the Charles Perkins Center, which looks at infectious diseases, the Net Zero Institute, the Sydney Environment Institute, the Sydney Nano, which looks at amazingly interesting nanotech stuff, the Sydney Policy Lab. So the question is, what in the world is the Sydney Southeast Asia Centre doing there as one of the 7 multidisciplinary institutes of the university? Well, our job is to accelerate the research impact of amazing projects like this in Southeast Asia. That's our mandate. And we do that by connecting collaborative research groups. We help those research groups gain access to funding, and that includes seed funding, which this project is a recipient of. So we're all very excited about this project because it's so new, it's so interesting. And the third one is to communicate the impact of these research projects to as broad a network of stakeholders as possible within Australia and across the region. So and this is the best part of my job as Deputy Director, I really get to see the coolest stuff that goes on in the entire university. And by far, I must say, Lemuria, this is one of the coolest ones of all. Thanks so much, everyone.
Thank you, Sandra. All right.
Thank you. I'm Azrini Wahidin, Head of School of Social and Political Sciences. I want to take a minute to acknowledge that we are on the land of the Gadigal people and pay my respects to elders past and present. It's with great pleasure to introduce to you our speakers for today. Dr. Hazrina Hamid is a senior lecturer at the University of Malaya in the Faculty of Law. She was called to the bar in 1997. She obtained her PhD in 2020 from the University of Wellington, which makes her almost local. Her research area focuses on human trafficking, incarceration, ex-combatants, and gender. She's recently been appointed as an expert by the International Criminal Court in human trafficking and counter-terrorism, and is also the head researcher for the criminal law reform for Malaysia. The title of her amazing paper is called Artificial Intelligence, Crime and Justice, Opportunities and Challenges in Malaysia. Professor Simon Bronitt was the former head of school and the Dean of Law at the University of Sydney. He is an elected fellow of the Australian Academy of Law. Professor Bronitt is a distinguished scholar who has published wide in a number of journals across varying areas such as criminal law, gender, violence, policing, terrorism law, and corruption. Dr. Jose Miguel is a senior research fellow at Sydney Law School and is also an Australian Career Industry Fellow from 2025 to 2027. affiliated with the ARC Centre of Excellence for Automated Decision Making in Society. Their paper is entitled AI and Policing Discretion, Rethinking Law in Policing. And so it's without further ado, please give a warm welcome to our first speaker, Dr. Hasrina Hamid.
Thank you very much, Azrini, for the introduction, and I hope to do justice to the topic. Thank you very much, Lemuria, and also hi everyone, ladies and gentlemen. Thank you for having me here. So my topic is on artificial intelligence, crime and justice, opportunities and challenges for Malaysia. So basically in Malaysia, there's a lot of discussions around AI. We are looking at we even have a national blueprint. We're using a lot, increasingly using AI in a lot of areas, many areas, policing, filing, all sorts of software now has AI. The only thing is that before I start, in Malaysia, we have the technology not aligning with the laws, because technology is going at a very rapid speed, but the laws take time to change. Why? Because process of making the law, changing the law takes time. There's so much of bureaucracy involved. So yeah, so much for bureaucracy. So basically, the use of AI in courts was introduced slowly and it moved gradually in prior to COVID-19, but it started during COVID-19 around 2020, because we had the strict implementation of the movement control order. So at first the courts were all closed, but then after some time the court was saying that we cannot be having this, let us we have all the utensils, the apparatus, the instruments, and just let's do the physical court hearing. So then even we had the older judges now learning to use Zoom. Most of the hearings were done on Zoom platform. And then later on, they had a more systematic framework. They had, how they were doing the settling case online, mediation, and even prior to COVID, our filing system was done online. So we had an e-filing. So we didn't have the manual type of filing anymore, where you get the receipt, because everything went online. So many have viewed this unprecedented pandemic as a good opportunity for AI to be used as a judicial tool alongside the existing sentencing process. So basically, now the current situation, we have this AI being used in sentencing in the courts in Sabah. So basically, they have this in Sabah and Sarawak. They did this pilot project in Sabah. Now I think it's past the pilot project. They are using it. We even have mobile courts in East Malaysia, because there is many rural areas. So you even have to the extent that you even make it easier for people to come and have their case heard by going into these mobile courts. So, but then what it does is it gives this recommendation to the magistrate. So AI is being used to assist in sentencing in the magistrate's court, because most of the offences fall in the magistrate's court. But only for two types of offences. That's small drug possession, that's under Section 12(2) of the Dangerous Drug Act, and for theft, Section 380 for theft. Reason being because they had the most data for these two offences, and I think most cases were on this. So they collated the 5 years of conviction, the data, the sentencing, and they put it in a software, and they got that data. So basically, the sentencing works on the algorithm recommendation. Yeah. So, as I said, those two offences has the richest data set, and the AI sentencing guidelines, is known as ICOS. It was developed by Science, that's a short form for something, which is a state government-owned company called Sarawak Information Systems Sdn Bhd. And the Office of the Chief Registrar issued a press statement announcing that AI-based sentencing guidelines would be adopted in Peninsular Malaysia Session Courts and Magistrates Court. So it was implemented first in Sabah and Sarawak courts, and then only later in the Peninsular courts. And the primary goal for applying AI in sentencing is to assist the court in enforcing criminal sentencing and to achieve greater consistency in sentencing. Because what happens is that, for example, Section 12.2, you have all this magistrates court in many districts. Okay, so you're going to get one magistrate sentencing this person to 3 months, and then you get another magistrate sentencing the same type of offence for 6 months, and then you get another one 1 month. So this is disparity in sentencing for the same crime. So that's why they thought it's best to achieve consistency in sentencing by having this AI algorithm. Okay, so basically how it's being used, stage 1, there is this interface on the computer of the magistrate where he or she, the magistrate, will enter the accused details, age, citizenship, possession, drug weight, marital status, prior offences, and then stage 2, it will generate recommended sentence based on historical 2014 to 2019 data, but now it's until 2025. Well, at least 2024 data. So the longer you get, more data. And then stage 3, display output, the magistrate reviews and decides. So based on this analysis, ICOS provides a recommended sentencing stage. ICOS is the algorithm, that machine, which judges can choose to follow or deviate from. So as you see, this was the former Chief Justice, Tunku Maimun, this lady. So 2020, Malaysian judiciary passed sentences for the first time today using AI in the Kota Kinabalu Magistrates Court. Okay, so this was meted out. The court meted out this sentence to 2 accused who pleaded guilty after reviewing recommendations from the AI system. Okay. Now, in determining the appropriate sentence, a wide range of considerations are given by the judge, and concerns have arisen on the issue of fair trial with the use of AI algorithms in the mix, because AI software might lead to bias in sentencing. Therefore, Sarawak Information Systems remove the race variable from the algorithm. And lawyers say AI recommended sentence for minor drug possession is too harsh. So there's a lot of concerns raised by lawyers, law practitioners. I myself have raised a lot of concerns until recently, where we started, myself and Azrini, we started interviewing people, those important individuals who can tell us about how AI is being used. I think a lot of it stemmed from the misunderstanding of what AI does, but nevertheless, there's still concerns around it. So now, a lot of the concerns is based on fair trial. So they say that, it's unconstitutional because there's nothing in Malaysia's constitution that allows AI to recommend or give sentence or recommend sentencing. Because if you look at it from a legal point of view, whether AI is a legal entity, whether we have the living being, human being as a legal entity, and a company, a corporate as a legal entity, but where does AI fit? So there's a lot of concerns about that. So there's this one case, and only one case, that was brought to High Court on appeal. The rest of the cases have not gone to the appeal stage. So the facts of the case, the accused was charged and convicted by the magistrate for possession of 0.01 gram of methamphetamine under Section 12 of the Dangerous Drugs Act. The punishment for an offence under that section is a fine not exceeding 100,000 ringgit or two imprisonment for a term not exceeding 5 years or to both. Malaysia have very strict drug laws. So in addition to the charge, the accused was also concurrently charged under Section 15(1) of the Dangerous Drug Act as a user of a dangerous drug. So that is also criminalised in Malaysia, which we are trying to decriminalise actually. So at the magistrate's court, the accused pleaded guilty to the charges, and after using the AI sentencing system, the magistrate sentenced the accused to 12 months imprisonment from the date of arrest for the offence under Section 12 to run concurrently with the sentence under Section 15. This is notwithstanding that the AI system recommended that the accused be sentenced to 10 months. So basically, the magistrate gave a higher sentence as recommended by the machine, AI. So the sentences were passed taking into consideration several factors such as very high rate of drugs in the area. So the accused then appealed to the High Court. So the pro bono counsel for the accused objected to the court using the AI sentencing system. It was argued that the AI sentencing system is against Article 5 and Article 8 of the Federal Constitution, that's on the protection of life and personal liberty of a person and equality before the law. So the magistrate's answer to the arguments raised by the defence counsel was that since constitutional issues are not within the competent jurisdiction of a magistrate's court, the issues can only be determined by the High Court on appeal. Upon appeal, the High Court allowed the appeal, reduced the sentence from 12 months to 6 months, but they did not address the constitutionality issue. So until now, AI has not been decided on grounds of constitution. They are just keeping mum about it. They're just like, trying to navigate and not address this, which they will have to address sooner or later. So no reason was given for the reduction of the sentence, and the issue of constitutionality was not addressed by the High Court. So 4 points of observation regarding the design of AI in Malaysia. So it was initially court's database from 2014 to 2019. Now it's added up, to 2024 at least. And then 3 features are captured: weight of the drugs, age and employment record of the accused, and then recommendations, either sentence or fine or imprisonment, and a recommended percentage is given. So precedents assist the presiding judge to decide in applying the correct sentencing principles at what was decided by past precedents. So in this case, the recommended percentage given by AI is imprisonment of 10 months, which is based on a higher estimate probability of 54.31%. So they will just, what the AI does is that recommend a certain sentence, 54%, magistrates would give 10 months, kind of like that, and which the magistrate did not adhere to, deviated from. So, there's a lot of criticisms in this, and like I said, at first there were many things, the areas that was looked at, was criticized. There were many concerns. I think a lot of it stemmed from the people not knowing how the system works, lack of transparency as well, lack of knowledge. I don't blame people who criticize this because not much information was given. And the Bar Council is not happy with this as well because the Bar Council was not given the explanation on how AI is used in courts. So their concerns, among their concerns, is that AI may pressure judges to follow recommendations that lack context or compassion. So sentencing must consider mitigating factors, personal circumstances, and remorse elements AI may overlook. And then a robot judge does not appreciate and consider the facts of each unique case as well as the mitigating factors involved, and this may eventually lead to a denial of justice. AI risks in entrenching and amplifying bias against minorities and marginalized groups. The technology lacks a judge's ability to weigh up individual circumstances or adapt to changing social mores. So in sentencing, judges don't just look at the facts of the case, they also consider mitigating factors. And from my personal experience, I was a criminal law practitioner for 21 years in courts. You know, I have someone who has done a repeated offender, but then on that, so that was his seventh time being charged for drugs, and just about when the magistrate was about to give him a sentence, he lifted up his shirt and he said, you know, look at here, there's a surgery mark, I gave my kidney to someone. So, you know, things like that. Of course, you don't expect something that you won't think of to put in the data. You know, we should consider someone who donated their kidney. I don't think that will be inside, or organs. So, you know, many things. I can say that I've done a lot of cases. Each mitigation is different. A person's state of mind is different during the commission of the crime. So sometimes when people hear what is being reported, they don't see all this. But I can tell you, because I was a practitioner, so I've seen, I'm telling you real life stories. So the decision-making process of AI can be opaque, making it challenging to understand how certain recommendations are derived. Judges retain full discretion and are not bound by AI recommendations. This is the part that a lot of people are not sure of, because they think it's the robot that's doing the decision, making the decision. But it is actually assisting the magistrate. It's like a place where, you know, it's like a database where, you know, this happens, let me check, you know. It's like all precedents being put together for you to check and see that, well, you know, in most cases, what is the recommended decision? But the problem is that, and looking at Gen Z now, they are now being over-reliant on chat software, chat GPT and everything. So there is this worry that, you know, when you have this assisted sentencing AI software made available, you will not really use your head and mind and empathy and compassion when you actually give the decision, because it's quite easy to look at, you know, I better take the one recommended and it's safe. But nevertheless, as I've mentioned earlier, whether they adhere or they depart from that recommendations, they have to justify. But let me tell you, as a practitioner, justifying is an easy job, because we can do that easily. If I want to follow, I'll justify. If I don't, I will justify no. So, you know, it has a lot of cracks around this that is yet to be addressed. And also on the issue of biased data, because the AI's recommendations are only as unbiased as the data it is trained on. Okay? So AI systems often do not reveal how they reach sentencing recommendations. That's another concern, because lawyers, they do not know mathematics. They're really bad at mathematics. They don't know, really, and that is true, let me tell you. I know this for 100% sure. Accounts, they're really bad at it. Let alone how AI works with all the numbers and how you do this. You know, you can cheat us anytime with this. So they do not know how it works. So they are like, how does it give recommendations? How, on what basis? How does algorithm works? A lot of people in the judicial system, even in the criminal justice system, they're not sure how it works. So the accused may not understand or be able to challenge how decisions are made. Let's say, how are you going to challenge the recommendations done by the system? That's not done yet. But the thing is that the Malaysian government is saying that no, it's not the AI who's making the decision, they're just assisting the magistrate. That's what they keep saying. But like I said, although you say that, but there is a tendency to rely on that. So that's the thing. And then you can see it risks violating the right to a fair trial, lack transparency, and replicates bias. So Malaysian court says that, okay, we want to be a little bit fair, we take out that race element to make it fair. But still, when they remove the race element, it's the same concerns arise. Okay? So, this one, in Malaysia, only an advocate and solicitor of the High Court, who's a qualified person under the Legal Profession Act and holds a valid practicing certificate, has a right of audience in court. So AI systems are not legal persons in law, therefore it's clearly not a qualified person to appear in court. This is one of the concerns. So how could AI be used to present arguments in Malaysian courts? So these are the concerns, yeah, but AI does not present arguments in court. But as time develops, it probably will happen. Like in China, they're like all out with using AI. You have a problem, you just speak to the machine and they will give you advice. So we are probably on that track. So as you see, sorry, I'm unable to understand, please try again, all these AI voice assistants. And in Malaysia, we have plenty of dialects. And then the tone of the voice. I mean, how you expect, if you're going to use AI later on, that voice detector AI, at the moment we are not using it, like I said, but as time goes by, AI is not going away. It will gradually increase and be used in all areas. So there are a lot of concerns on that. And now, as you see, even in Malaysia, even the government departments, if they have to give speech, if they have stage fright, or maybe they're not really fluent in Malay or English, if you're speaking to audience, they use an AI image. And it's quite funny, you have this guy speaking with American slang and that. So, that it's increasingly being used. And then accents used by Malaysian may not readily be understood by Western programmed AI. The way I pronounce is different from another person. Simon pronounced it probably definitely different. So, yeah. So I think this case, do I have time? Yep. So Loomis versus Wisconsin. So this is a famous American case. Only thing, this is a little bit different. They have this thing called COMPAS. In Malaysia, we have ICOS. ICOS is assisted AI, assisted intelligence something. It's like AI assisted sentencing. But for COMPAS, it's basically doing kind of a profiling. It's basically doing profiling. So in Malaysia, we don't use AI for profiling. We don't even do profiling because we only recently have a behavioral science unit just established. And even that BSU unit does not really do profiling. So here, in this case, the judge presiding the case was constantly inquiring both parties on how the technology operates. Surden notes that the issue of interpretability of AI systems and transparency around how AI systems are making their decisions may further complicate its relationship with the legal realm and the rule of law. So AI systems, in this case, the court said AI systems are built in such a manner that even the programmers may have an issue in deciphering the underlying mechanism. Using them to assist decision-making in areas such as criminal justice, where the stakes are high, has been considered dangerous due to the insufficient understanding of technology in question. So the Wisconsin Supreme Court addressed the issue of risk assessment tool called COMPAS in sentencing. The case involved Eric Loomis, who was sentenced to 6 years in prison, partly based on a COMPAS risk score indicating a high risk of recidivism. So this COMPAS is a bit different from the Malaysian one. Malaysian one does not do this. So Loomis argued that using this closed source algorithm violated his due process rights. The court upheld the sentence but placed restrictions on the use of COMPAS, including the requirement that the court provide an independent rationale for the sentence and a warning about the algorithm's limitations in present investigation reports. So in this case, Eric Loomis pleaded guilty to charges related to a drive-by shooting, a COMPAS risk assessment which evaluates the likelihood of recidivism was included in his present investigation report. So the dispute is that Loomis argued that using a closed source algorithm like COMPAS in sentencing violated his due process rights, specifically his right to a fair and individualized sentence. So the case went to Supreme Court. The court affirmed the sentencing, finding that the use of COMPAS did not violate Loomis' due process rights. However, the court also imposed restrictions on the use of COMPAS in future cases, including a requirement for the court to provide an independent rationale for the sentence, not solely relying on the COMPAS score, a requirement that the present investigation reports containing COMPAS scores include a warning about the algorithm's limitations, And the US Supreme Court declined to hear Lume's appeal, leaving the Wisconsin Supreme Court's decision in place. So the significance of this case is that because it addresses the use of algorithmic risk assessment in sentencing, raising questions about transparency, fairness, and the role of AI in critical decision making. Okay? So, conclusion, the use of AI in sentencing offers potential benefits in consistency and efficiency, but raises serious human rights concerns. Sentencing must remain a human-centered process grounded in fairness, empathy, and judicial discretion. And that's the thing about judicial discretion. To me, AI and sentencing, I can only sum it up to judicial discretion. Because law, the pillars of law, the underlying principle of law is that discretion is to be exercised judiciously. So, in Malaysia, we do not have a sentencing guideline, we do not have sentencing counsel. So, if the punishment is not prescribed in the act, and it's just open and says fine or imprisonment, it's up to the magistrate or the judge. So how do they actually decide? So we don't have a sentencing guideline. That's why we have this inconsistent kind of punishment given, sentencing given. Hence the use of AI. But even with AI now, it's assisting the magistrate. There's still concerns about it. Okay, so Malaysia must adopt a cautious rights-based approach to ensure AI supports and not undermine justice. Okay, that's all. Thank you.
Any questions? Questions? And if you go to the next slide, we'll pull up the Slido again.
Yeah.
So those of you online, feel free to log in the Slido and submit your questions if you have any. But anyone in the room, questions or thoughts? Yes, and I'll share this mic, and if we have other mics, we'll bring those up. Let's come.
Hi, my name's Rachel. I'm just curious, you mentioned the fact that there weren't sentencing guidelines for a variety of offences. Why was it considered more practical to have AI recommend rather than
sentencing guidelines? Yeah, actually I can't give you the answers. There is no answer for that. That's a good question. Sentencing guidelines, I'm not sure why they do not want to have that sentencing guidelines. It's probably also political related, I'm sorry to say. But they thought it's easier to use AI because they want to follow the flow, and they straight away use AI during COVID. And it's like, straight away, unprecedented, let's just use AI, we have this software, let's make use of it. Sentencing guidelines, they are a bit slow, and I've been appointed as a head researcher, even I have been asked to prepare a sentencing guideline, and I haven't even started. So I do feel that you really need a sentencing guideline. They do have this kind of guidelines, but it comes from practice directions. That means, they will get, according to the scenario, the current scenario of the country, like there's so much of drugs, there's so much of theft, and then suddenly you get this circular from the Chief Justice Office saying that go hard on cases like this, deterrent, because Malaysia is still obsessed with retributive deterrent rather than restorative kind of justice. Yeah. So, yeah, I hope that answers you.
Thank you. Any other questions in the room? We do have one online, but if you have a question in the room, feel free to raise your hand and we'll bring you a mic. We have a couple coming in online. So, is AI being used in the Sharia courts?
In the Sharia courts? Yep. No, it's not.
No? Okay.
Yeah.
Are there any latest developments in Malaysia's adoption of AI in the criminal justice system since the talk in KL a few months ago in July? So we have someone joining us online who was at the workshop we did in KL.
Yeah.
You gave a similar presentation. Any updates since that one that this person may be interested in?
Okay, thanks for the question, but no.
No, all right, it's still emerging. Okay, thank you. This one says, how are AI courts being processed in each criminal case?
How, again?
That's the question.
how
AI court being processed in each criminal case?
Well, how AI court is being processed in each criminal case. So
Yeah.
I don't know whether we have an AI court. Actually, we don't have an AI court. I know in China you have
Maybe they
AI
mean the
court
mobile
in
courts.
Estonia. Pardon?
Maybe mobile courts? Maybe we can talk a little bit about how mobile courts are being used and is AI showing up in those mobile courts?
Okay, so even in mobile courts, you have a real life magistrate there. So the only thing is that you have that machine, the algorithm, that machine that gives that recommendation. So they do use that. So it's basically not, in Malaysia, it's not the AI that's giving decisions. It's still a real magistrate giving decisions, but they just use the AI system to see the recommendations. Like I said, the reason they do that is to promote consistency in sentencing. But whether the magistrate adheres to that or not, the magistrate will need to provide justification. So that is currently that. And the latest I heard was that only 33% of recommendations was adhered to. The rest, the magistrate does not want to adhere. But like I said, I'm quite worried about Gen Z with the over-reliance on all this ChatGPT, DeepSeek and all this thing. So they might then just keep listening to the AI machine.
Yeah, no, I think that's a good one. So we have a couple more. I'm going to jump to another one that's related to your response. Are prosecutors using AI in the exercise of their discretion?
Oh, no, they're not.
They're not,
They still
okay.
do the hard work. Although they use a lot of ChatGPT, I know that.
Another one, what was the rationale given for adopting AI? Was it a cost efficiency calculus?
Yeah, cost efficiency one, and then there's backlog of cases. There was so much of backlog of cases, especially, per day, a typical magistrate court will get about 150 to 200 cases being mentioned. A smaller one would get less. So I think they want to make it quicker rather than, because what happens, let me tell you, traditionally, I've got a lot of friends who are magistrates and judges also. I know this is a bit freaky what I'm going to tell you, but that happens, but never mind. I'm a law practitioner. Sometimes I get my friends who will call me and say that, oh, I got this guy who slashed someone. Do you think 7 months is enough or 9 months? So I'm like the AI. So sometimes I will give myself like, is that the first offense or whatever? I think 9 months. So it takes time. So she or he will stand down the case and start looking around for a suitable sentence, and that sometimes take 2 days. So with AI, sort of you have this pool of cases, a pool of precedents, and you can just check, that most cases, most magistrates would give probably this length of time. So it kind of saves the time in that sense. Yeah.
Very nice. Any other questions or comments from the room? We're through all of the Slido. If not, we will thank Rena so much.
Thank you.
All right. We appreciate it. Thank
All right.
you. You're done. All right. So next up, we will continue this wonderful discussion and move into a different area within the criminal justice system and look at policing and the role of AI in policing. So I'm going to invite our next two presenters to the stage. They are already have their mics. Here is the clicker. So Simon and Jose, over to you.
Thanks so much. Thank you to the business school, obviously, for inviting us. Thank you to the Faculty of Social Sciences and to SIAC, of which I am a member. I am always grateful for making the time and the space for these complicated but interesting discussions. And just to explain what we are going to do here, I'm going to start. I've been researching the governance of AI systems and automated decision making for a while. When I started more than 5 years ago, when I was telling people that I was looking at the governance of AI, I could feel people moving in a different direction. 3 years later, it started being the opposite dynamic. People coming to me and saying, would you do AI? Yes. ChatGPT happening in between. And then obviously the expert in policing is Simon, so I would leave that stuff to him to explain it. He would do it a much better job. But probably we are very lucky without clearly coordinating our presentations. We are very lucky that Loomis was discussed before, because you all have heard of COMPASS. And pretty much what COMPASS stands for is the Correctional Offender Management Profiling for Alternative Sanctions. So it is a CMS, but probably it's a decision support system. So DSS is a decision support system. So it's meant not to make a decision, it's meant to help a judge make a decision. And obviously, as we heard, it's assessing the risk of recidivism. It gives a range of risk of recidivism. So here is where our presentation comes in. We're thinking, well, we all know the problems of AI. We hear about them and automated decision making, as I'll refer to continuously. But what we do not think about that often are the trade-offs. And COMPASS, which was a system that was badly designed, and it shows some degree of bias, even if later research showed that the bias was not as bad as the average judge, you have to ask these questions. You have to ask first, what is the human baseline? So how are judges doing their job right now? Are they biased? And if they are biased, does the system introduce less bias than before? So, and who do they have to outperform these systems? Do they have to outperform the average judge? So Mr. Loomis, when he was coming to court, was he better off having an AI system than having the average judge? Or should we ask for systems to outperform the best judge, or the 10% among the best judges? Like, where do we put the threshold of the human baseline? And what are the trade-offs? As we heard before, in Malaysia, it was an issue of backlog of cases. That was the reasoning in the US as well. So if you got arrested on a Thursday, you were meant to appear in front of the judge on a Friday. If the dock was full, you were not going to appear in front of a judge on a Friday, which meant that then it was the weekend, so you were spending the time until Monday. So you were going to be in the local jail for, 4 days, close to 5 days, instead of appearing in front of a judge within 24 hours or 48 hours. So the whole point of this system was reducing also that time. So there is a trade-off. You're introducing bias, you're introducing risk, lack of explainability, removing part of discretion, but at the same time, you are promoting the rights of the accused person or the arrested person, because they are going to have a day in court faster. And you always have to think about alternatives. What are the alternatives? Normally you can say, well, I can double up the number of judges. Yes, of course. That comes with costs, training, different issues. Normally I'm always in favor of first thinking, how can you solve that with known technologies, solutions? And how much is it going to cost you? What is it going to entail? And from there, you can decide when you're doing or changing. Okay, and we're going to keep referring to AI and ADM. Why? Because normally people do not, I mean scholars, academics, policy people, lay people, do not know what AI means, and it's perfectly justified because no one knows exactly what AI means. We try to give definitions for AI systems. So I tend to prefer referring to ADM, automated decision-making systems, which is like, well, you have a technology that you're using to help you with the decision-making at some point. And that decision-making, if it supports a decision, is normally what is called a decision support system. If it replaces, it's a full automated decision-making system. But may or may not use AI techniques. And AI techniques, let's not get into that, but pretty much rely on some form or another of machine learning. I'm oversimplifying a lot here. So, what is the AI ADM dream? It's systems that produce objective, lawful, bias-free, in our case, in our paper, police decision-making, that is more effective, so it is a much lower cost. So it outperforms humans, and on top of that, it's at a lower cost. But what is the nightmare? Like systems that produce a prejudice, and on top of that, that we give them the legitimacy that they do not have. Because, well, if they outperform humans in this way, at least you can say, well, they're gaining recognition in terms of legitimacy because they are doing better. But we cannot assume that machines are going to do better than humans by default. Why? Because you can have skew data, bias predictions, you could apply, over-amplify existing biases, especially in the context of policing. And the worst bit about it is you say, well, the machine told me to do so, that's why I'm doing it, without challenging why the machine told you to do that thing. And I'll leave it to Simon to take you through the issue of policing. And
thank you, Jose Miguel. So when we think of policing and the law in policing, I think it's a useful starting point to think about the authorising environment. Now that's a phrase that was first applied to civil servants, public servants, but was applied to police as public officers in David Bailey and Clifford Shearing's very thoughtful paper, which in many ways stands the test of time, The Future of Policing in 1996. And for policing, the authorising environment is not just the rule book, the legislation, the powers. We have Police Powers and Responsibilities Acts now that set out powers of arrest, search, stop, all of those key norms governing general duties policing. They're all set out in statute today. At an earlier point, they were more likely to be found in case law, common law, and something that occupies a somewhat ambiguous status called the Judge's Rules in the early 20th century, a soft law document where really, in a sense, our right to silence and the practice of giving cautions before interview were set, not by legislation, not by a case, but as after a judicial conference with senior police, they came up with this set of instructions, very influential instructions that were adopted here in New South Wales, that became the New South Wales Police Commissioner's instructions, and now are codified into legislation. So we have, if you like, hard law, that's found in statute. We have obviously key cases that explain that, but we also have administrative guidelines. We don't call them Commissioner's instructions, but the kind of operational police manuals that contain a lot of important information in good practice framed against the legal principles and rules. And then, of course, we've seen in the last 30 years the professionalisation of police. And so police, like every profession, has sought to develop its own sets of codes of ethics. And these are also other normative resources. So in some senses, you can see policing has gone through transformations in the UK and in Australia and in the US, contrary to the 1970s Dirty Harry view that policing operates outside of the law, or to get the job done you needed to break the law. I would say that modern police are very cognizant of the normative thicket that they operate in. It's thick with norms. Some of them are statutory, some of them are even constitutional. In America, of course, they're constantly talking about amendments to their Bill of Rights, 4, 6, first even, and they become norms that hedge policing, say around protest. But that's not the totality of the forces that explain policing. And I think this is where, and I'll get to this foreshadowing my point, is a lot of developers, system developers, automated decision-making system design is going wrong, and I'll come back to this, is that they're thinking of law and the policing legal framework as a set of rules, and that's the totality. And they're ignoring the diversity of norms that play on police decision making, but also the role of discretion, and I'll come back to that. Legality, of course, is at the heart of policing because it is tied to legitimacy, and that came through in the first presentation. In the context of policing, clearly they have a responsibility to the law, they have a responsibility to enforce it, and in equal measure, they have a responsibility to obey the law themselves. So in the executing their duties to apprehend offenders, to keep the peace, they have to respect the law, but they also, in discharging those duties, they are bound by the law. And that's an aspect of the rule of law, that's fundamental. But it's not exhaustive of the police mandate today, and you can even say today, and particularly in jurisdictions, not New South Wales, but say the UK and Victoria, ACT and Queensland and Australia, human rights legislation is another set of prescriptive statutory norms. We don't have a Bill of Rights in Australia at the national level, but not in New South Wales. We don't have a Human Rights Act. These are important norms that are relevant to policing. So human rights policing can become really transformative in certain places. Northern Ireland is a great example. If you want to see human rights policing in action, in the difference between the law in the books and the law in action, but I think quite realistically is the SBS series from the UK, Blue Lights. And I think it's really fascinating to watch the language even of the police officers as they go about their very difficult task of policing sectarian communities in Northern Ireland. Not least of all the way they frame, you'll see this line, which I really like in one of them, when they really panic, when the shit hits the fan, to use the police expression, it's an Article 2 situation. Now, what does that mean? Well, Article 2 is the European Convention on Human Rights, and it is essentially the right to life, and that actually is triggering a higher level of the right to use lethal force, which of course has been subject to litigation before the Strasbourg court. So it's really interesting to see how that language transformation in policing has happened in one place, but leading to at least ostensibly a much higher level of awareness of the importance of policing human rights and the legitimacy that confers. But I want to also emphasise that legality is not the beginning and end of legitimacy for policing. And this is where ethical considerations, and I've called this the lawful but awful problem, and there are two cases that I like to talk about in relation to that. One is the Kennedy case, and Mark Kennedy was an undercover police officer for 7 years under the RIPA, under the Regulation of Investigatory Practices, I think it is. It's a terrible misnomer. I don't know what you call that, but very clumsily expressed act. This undercover operation was authorised. It was lawful. So Mark Kennedy was an undercover cop that actually infiltrated a group of environmental protesters. He was a very senior member of that group. He developed and organised protests that were very disruptive. Some were targeting nuclear fission sites, nuclear power stations. Some were causing mass disruption in London, obstructions of roads and so forth, criminal damage. And he would be arrested and released, and he was at various points on the run, but he was actually an undercover police officer. He formed a relationship with one of his members of the protest, and then one day he just disappeared. What was later revealed, really through a Guardian investigation, was that he was an undercover operative feeding information constantly into the Metropolitan Police, and that was never disclosed to the people that were being prosecuted for various offences, and he also fathered a child out of that relationship before he then disappeared on the run from the police, heading to Europe to reinvent himself. Of course he didn't, and he bumped into his former partner several years later, and that's when the truth came out. He suffered PTSD, I think one could say, from that period of service, and it precipitated numerous inquiries and there are some still going on 10 years after. You can't say that was unlawful. It raised deep questions about the ethics of those procedures. It was lawful in the sense that it was regulated by statute, that at each and every point it had a rolling authorisation, and it illustrates the point that things can be lawful, but they can remain awful. We have our own Gobbo case here in Victoria. This is a criminal defence lawyer who was basically turned to be an informer. She was became the preferred defence lawyer for the organised crime, those alleged to be the organised crime leaders in Melbourne, and over a 10-year period informed against them to the Victorian police. Again, none of that was obviously disclosed in the process of the prosecutions and convictions, raising very serious questions about the ethics of those operations. You can't say they were rogue operations. They were authorised and approved at the highest level of VicPol. So I think, we've got an issue around here. How do we deal with reform in this area? Well, it tends to be these crises drive reform. It's piecemeal, ad hoc, and it inevitably comes after the event. And one of the things that I like to think on the positive side around technology, if we can embed some of these normative principles and guardrails that we might be prompting to the officers who are making key decisions in a whole range of domains not to fall into both legal, human rights and ethical traps. So that's the prospect really of where technology could lead us. Most fundamentally, we have to really understand the role of police discretion, not as something that is considered to be an anathema to the rule of law. I mean, underlining some of the questions about sentencing and inconsistency is this misunderstanding of discretion. Discretion is inherent in policing. It's often misunderstood. It's considered to be synonymous with arbitrariness. I think Dicey in the 19th century called it the tyranny of arbitrariness. But discretion is essentially a framework for, in the application of the law, to tempering legality against other legitimate considerations. The key issue with discretion is it needs to be bounded and it needs to be transparent. When we think, and this is David Dixon, former Dean of UNSW Law School in English and Australian scholar like myself, did a comparative study of PACE, the Police and Criminal Evidence Act, in the UK and New South Wales in the 1990s, and on this we're in furious agreement. The danger is always when we think of policing as a framework governed by rules, or that the police conceive of law as a system of rules. In truth, they operate and operationalise law as tools. I mean, they can be operationalised in better or worse ways, there's no doubt, and some of the interpretations can be flatly wrong or even legally contestable, you could say. But that is the nature. Even though the police will stand, if you're stopped and you say, why are you picking on me? Well, I don't make the laws, I only enforce them. Police in their interactions with citizens will often emphasise they have no discretion, and that's not true, of course. Police have huge discretion. And the danger is, of course, as we know from countless empirical studies, is that discretion tends to be favoured, exercised in favour of people like me and Jose Miguel, and not against young Indigenous kids in regional towns if we were doing exactly the same thing. Maybe we're drinking alcohol in public, both of which can be technically an offence, or swearing, that great Australian practice that remains an offence on the books in most jurisdictions, using offensive language in a public place. I think most people in Australia probably are guilty of that at one point or other. You won't be arrested and prosecuted except a range of categories of offenders. Vulnerable communities are over-policed around offensive language. So I've called this mind the gap. If you travel to the London Tube, you know there's always a gap between the law in action and the law in the books. You know, that's inevitable. There's this gap also, which I've just outlined, between legality and understanding discretion. And they're not, I don't like to see them as intention in that, you know, antinomies. You also have crime control and due process. You can see all of these dichotomies. I think we have to really move beyond thinking in these binary ways. And so this is the rethinking that I propose. And what I have here is all credit to Norval Morris and Gordon Hawkins. 1972, this was, I think, pretty much the first bestseller of criminology. It was published in the States. It was directed to an American audience, that was published by Norval Morris, who was an Englishman, and Gordon Hawkins, who was an Australian, which is interesting. Gordon Hawkins was our first lecturer of criminology at Sydney University. There's a bit of a local context. And it was really written against the war on crime, the war on drugs that was emerging in America. And they called it the Honest Politician's Guide to Crime Control. They really wanted to show that, you know, there are a whole range of assumptions that are underlying this moral panic about crime, and we need to be more cautious in developing our criminal justice responses. I think we need to develop the equivalent as an honest AI developer's guide to crime control or policing or sentencing. What we need to do is to be more honest about the nature of law when we design these systems, and not keep reiterating this idea of law as rules. Stop. Legal uncertainty is ubiquitous and inherent in the nature of any system of rules. There's going to be interpretation and differences of interpretation. And how is that uncertainty resolved? Well, sometimes by litigation, but mostly not. That illustration of picking up the phone, of a judge picking up the phone and asking a seasoned practitioner, what do you think, is actually part of that tacit knowledge of how systems work that seek to resolve that uncertainty. Academics make their life out of trying to resolve and explain uncertainty. So we need to be striving in our systems, not to a perfect outcome, but what we should be aiming at is reasonable legal certainty, which incorporates, of course, the formal legal sources. We have to incorporate, and foundationally, statutes and reported cases. But we also need to look at the law as it's practiced, the law as it operates in the real world, and that's the law in action. And that's the consensus that's based on those expert people who interpret this, which might be groups of lawyers, police and scholars. This is not simply the published views of those few matters that reach the High Court or the Supreme Court out of contentious litigation. We need to know, because in 95% of the cases, people plead guilty, cases are solved without ever going to court. So we need to understand how the law operates in practice. And so we can't just keep focusing and fetishizing the superior court rulings. And there is an example here, and I like this. It's only been going for a year and a half, but it's a good example of the challenge of building systems to help people in practical ways, and it's called Amica. And it was developed by our federal family court to help families that are going through contentious divorces, property settlements, and really to get rid of the lawyers as far as possible. And that's got to be a good thing, because they're just expensive and they get in the way. So it brings the parties together in a platform where they go supported by basically a decision support system that, you know, it's kind of almost like a chatbot. So the people are linked in a conversation in a chat room, and they're discussing things and they're arguing over things, and it makes prompts. It provides information to assist the resolution of that matter. Now, of course, there's all risks of coercion, and we know that, you know, in dispute resolution, that women can be quite vulnerable to being essentially bullied or coerced into accepting settlements that are not in their interests. The system has built in safeguards. including when language becomes more expressive and angry, the system will intervene. I haven't seen it in operation, but apparently it's been going for about a year and a bit. Interestingly, when they've developed the system, they built it around reported cases. The cases on the systems that had gone to a full hearing and contained the key normative principles. And then they launched it on a kind of a test group of practitioners who came back and said, it's rubbish. This is not how it works. So they basically then rewrote the system to codify how the practitioners applied the law to achieve amicable settlements. So it's very interesting. I think, again, to me, there wasn't a huge amount of publicity around this process. I've only been able to get slices of perspective on this from a handful of press releases. But it seems to me there are some important lessons we can learn about systems that are working well and how they were designed. Of course, it's all behind a black box, and this remains one of the challenges in this. We have systems that are working now, like Compass which stand behind proprietary black boxes developed by corporations, usually based in America, as in fact is the Amica case, as I recall. So that's enough from me. I'll turn tables and.
So I'll try to wrap up all of this, and I know that we are over time. So, what we added to this question is a discussion on noise that probably people from the business school are quite familiar with. In the social sciences, is the cognitive aspect, and it's based on a very famous book that was published in 2021 with Kahneman, Sustain, and Simonie, a French academic as well. And pretty much what they say is that you can actually look at noise. You can actually look at bias. Let's just put it that way. And I'm oversimplifying one more time. And you could see that sometimes systems are accurate. With court judges, it's much more difficult to tell when they are accurate or not. But let's just leave that aside. It could be systematically biased. It could make decisions against a certain group or a certain profile or in a way that is. It could be noisy, meaning that among different judges you may have different decisions, among different police officers you can have different decisions for the same type of situation. Or it could be biased and noisy. So it could be a divergence between the people making the decisions, but also a divergence in terms of everything is skewed in one direction. So what we are proposing, I suppose, it's if we look at the existing practice and we can identify this type of bias and this type of noise, we can get systems to help criminal law practitioners, judges, police officers, prosecutors, to be conscious of the bias or the noise that they are entailing. Going back to the Malaysian example, the system may help judges be aware of when they're giving a sentence that is too harsh or too lenient, according to what the norm is. It doesn't mean that they have to follow the suggestion, because there are things that are not going to be taken into account by the system, but it may reduce the excessive variance that two different judges may find. So getting in front of this judge or in front of this judge can give you two different things. But at the same time, if you look at the data and the system is refined, it could tell you when the data and the outputs are skewed in one direction. So the whole point of our paper, of our discussions, of something that Simon and I have been thinking for a while, is that legal and non-legal rules need to be operationalized in these systems. And it's not enough to just get systems that give you an output and you follow that output. You have to look, well, how is the authorizing environment? Is reasonable legal certainty a realistic goal? When you have discretion, how are you going to apply that discretion? And can machines apply that discretion? Well, the Federal Ombudsman has now told us that it is allowed for machines to take into account discretion. And when we say positives rather than negatives, we would like AI systems and ADN systems to help mitigate the kind of noise between different judges or different police officers, but also make us conscious of the biases that we may have as a sector. So ideally, we would design systems that help humans be more reasonable, more legitimate, and exercise discretion in a better way. And thank you very much for your patience. So, if you
Thank you both. Any questions? Questions from the room? We have our Slido questions also available. So again, if you haven't already done so, feel free to take out your phone and join in on Slido. Thank you. And while people are getting started, so I definitely will get us started with a question. I thought it was very encouraging to hear you talk about systems developers, because the way systems are designed, the data that's used, the way the data is trained will have a big impact on what comes out. So are you aware of kind of any good partnerships between developers and lawyers to do this well? Or what's happening in that space? Interesting smiles in response.
I go. Okay. So part of my research is to work with the public sector in the deployment of AI systems in the public sector. And I have seen it from the inside, and I have seen it from the outside. Let's just put it that way. And it's very interesting because right now, let me just take a step back. Public sector is capable of influencing the market and the way things are developed. So because it's a big buyer of these systems, if they ask for certain specifications, certain qualities from the systems, they are capable of getting the developers aiming for certain objectives that maybe if they were only serving the private sector, they would not be able to, or it would not be at the forefront of their thinking. And in that sense, what I have seen in the last couple of years, both in Australia and in the EU, and honestly in the US as well, it's that when public sector agencies are asking for certain systems to achieve certain objectives, they're being much more conscious in their procurement clauses about what they want from those systems, what the expectations are. So the developers are reactive to those signals, and they want to be able to sell to the government. And the kind of systems that they are developing are much more responsive to issues such as bias, definitely, but also some degree of explainability. They have been trying to build that into the systems that they are developing. Or very often, when they have systems that they are developed, that they could keep monitoring them and assessing the accuracy and potential biases once they are deployed. So we all tend to be very negative, especially academics. We tend to be like bashing government and bashing developers for what they are doing. I have to say that if things go the way they are going, or the way they were going until a year ago at least, we were seeing a significant improvement in how developers were looking at the mistakes that they made before and how they were trying to redress them. There is also an element of complacency. It was, well, we have addressed with race bias or gender bias, so let's forget, we have done that with the data, we cleaned the data, we have tested for that. Well, there is much more than that, and obviously that's probably the next frontier in that kind of relationship.
Yeah, definitely. I do have a follow-up, but Simon, anything to add? And again, anyone from the room, feel free to jump in. No, good? So encouraging to see people are definitely addressing some of the challenges, and the developers are, but how are we checking to see if they've been addressed adequately or actually addressed?
Okay, I'll take that one because it's something that so when we started developing regulations for AI in general, I have some technology background and data science background. And I was quite convinced back in the day that it's not possible to create certain rules ex ante before we actually deploy the systems. So I was thinking, well, our efforts should be on the data of what the system is generating on the outputs. So if we keep tracking the outputs, and see how things are going once the system is in place, and theoretically speaking, with A/B testing, so you have humans doing when there is a replacement. You have humans doing the work, you have machines doing the work, and you can compare how both are doing before you actually shift to automation fully. That would be the best way of doing it. What is the problem with that? That is awfully expensive. First, people do not care that much about monitoring because, well, the system is deployed, I have my efficiency gains done, so I can forget about it. That's one. And second of all, when you tell them to do A/B testing, anyone who's like managing funds, they will tell you budgets, they will tell you, oh, you don't want efficiency gains, what you want is to duplicate what we're doing. I say, yes, that's precisely what I want, because efficiency gains will come down the track. But at least when you have those efficiency gains, you would have assessed the system and have a proper data set to say, well, this is where the trade-offs are. This is what we gained, this is what we lost. Obviously, it's a fight. Every time that I give a presentation on this, I say, I'm always on the losing side of these discussions. So it doesn't matter what it is, transparency, I'm on the losing side. Efficiency gains, I'm on the losing side. So, but I like to keep fighting at least for a little while longer.
That's great to hear. Keep up the fight. Okay, we do have a Slider question. How is AI literacy being integrated right now in criminology, police education in Australia? And what are the best integration and adoption use cases of AI literacy in crim or police education?
One of my colleagues, who's a professor in Montreal, Benoit Dupont, wrote his thesis on police technophilia. Sounds like a disease, really, doesn't it? But it's actually really tracing how police, we think of them as inherently reactionary and conservative and opposing change. But if you look at the broad sweep from the first telephone, you just have to be a Doctor Who fan to know about the TARDIS as a police box, a phone box, when there weren't that many phones. The use of motor cars, mobile policing, the first computers, word processing, databases, profiling, obviously predictive policing, and we've seen this in Compass. And these are not new systems; they've been going for a while. I think I think in terms of the academic environment, I think there are plenty of courses on technology and law. And in fact, with colleagues at ANU in 1995, I set up IT law course, and we looked at some of the issues around AI and automated decision making, as it was really then. It didn't have the capabilities that it has now. And so there be, in some senses, the curriculum, that first chart you showed is this kind of rise and fall, but then it rises again and then it falls. And I think that we're just in probably the third or fourth AI revolution, frankly, for those who've been kind of thinking about this for a long time. I think there'll always be in the academic community and in the policing community champions. And in Malaysia, you can see that wouldn't have happened but for a group of tech bros in the judiciary saying, we want to take an opportunity here to do some experimentation. So I think entrepreneurs matter a lot. I'd like to see some entrepreneurs that aren't just driven by new public management thinking and efficiency gains, but also on human rights and legitimacy and ethics, and how we can kind of make sure that the technology incorporates and embeds that as fundamental code, which I think at the moment isn't happening. But I think there are always in every community those that embrace the technological, whether it's the university or New South Wales Police. I think at the moment they're probably investing a lot. The danger, of course, is the American commercialization models favour companies like Clearview that are making lots and lots of money selling very, very, put it technically, dodgy systems that are trained on data scraped from social media sites. So I think there are legitimacy concerns around how some of the systems that are now being marketed to police forces, some of whom are not terribly sophisticated in their uptake. And America has a lot of policing agencies. We think we have a lot. There's more than 500 because of the highly decentralised model of policing that goes on in the States. So it's a variable uptake, I think, probably across Australia and across the States at this point.
Yeah, thank you. In reference to that hype cycle and kind of the ebbs and flows, I've heard someone refer to it as AI summers and AI winters.
Yeah.
And so we'd be in an AI summer at the moment.
Yeah.
So thank you very much to both of you. I'm going to invite our panelists to join me at the front. I'm going to sit here. You all can join in.
I just got this glass. So keep myself.
Thank you. All right. So we are going to spend the next 25 minutes or so having a panel discussion, continuing on with our discussion of AI, criminal justice, looking at policing, sentencing. And to those of you online, please do continue to chime in. I'll leave the Slido up. And if you want to join us live on a mic in the room, we'll definitely be able to accommodate that as well. So I'll start us off with a few questions, and then we'll open it up. We'll check in with Slido and see how we're going. I thought it was really interesting how your presentations definitely complemented each other and played off of each other. There were several things that you both mentioned or all mentioned when you spoke, so maybe I'll start there. Both of you mentioned the U.S. I'm going to start there. You can hear my accent. I am from the U.S., and that's not why I'm asking the question, since you both raised it. When you think about the criminal justice system in the U.S., how do you see developments there, cases there, initiatives there, impacting practice around the world, and in particular in Australia and Malaysia? So, big question. Maybe I'll start with you, Simon.
Yeah.
You gave me the most reaction on your face. So.
Yeah, well, look, I was the director of the Australian Research Council Centre of Excellence in Policing and Security for 5 years, and worked very closely with American policing scholars. And America is a very large jurisdiction. It has the advantage that with that level of jurisdictional diversity, and we always think about the FBI, it's always, they're like considered, but they're actually got quite a small jurisdiction. They may have the best and high profile in the public, but that actually allows for an enormous amount of experimentation in policing. And so you get in America policing that is community-led, restorative justice looms large, and then you get kind of militarized zero-tolerance policing developing at the same time. So it becomes actually very hard to talk about American policing per se. You can say, well, this is the practice that's favoured. What that level of experimentation does is that there's an enormous amount that can be exported, and with American entrepreneurialism in policing, it is. And I have to say, whether it's the war on drugs and the policing techniques used, particularly around undercover policing, I think from the 1970s onwards, largely driven by developments in federal FBI policing. So I think hugely, the short answer is for good or bad, and sometimes it's for good, sometimes for bad. Policing is very influenced. There are fundamental differences in investigation, though. I do think that English, British, and Australian policing has adopted a model of investigation that is less adversarial now. I think since 1984, the Police and Criminal Evidence Act, I think you've seen development of a much more open and fair process of investigation because of all the scandals in the previous decade. It's not to say scandals don't happen today, but in America you're still training on almost, you could almost say, the third degree. There's still a higher level of threats and force and dishonesty, deception, that's used in investigation than would be acceptable in the UK or Australia. So I think there are differences still.
Thank you, Simon. Rena, how about you? How is the U.S. impacting criminal sentencing in Malaysia?
Okay, a very interesting question. Malaysia has mixed views about the U.S. As a Commonwealth country. I think one of the problem is that the government and the structure is still very colonized in that sense, very neo-colonized at the moment. So I think they look at, they try to follow the precedents from the UK, India and Australia more than looking at the US. But the funny thing is that when it comes to police training, they like to go to the US. And the US, despite being always being criticized, always until recently after Trump, have always been generous in organizing, giving funding for training and all. So even like some of my good friends in the Royal Malaysian Police, they are Quantico trained and they were very proud. I think the only thing that we talk about is the use of body cams, which is good. But I think there's a lot of talk about the oppressive practices maybe, and then the racism that is being highlighted. I think also the thing is that Australia get the news in a different way than we get the news. So a lot of our perception comes from the media. So what is we get a lot from Al Jazeera, the ones that's being portrayed in our local news does not show US sometimes in a good positive light. Also there's a lot of worry and concerns about this wrongful conviction, a lot of wrongful incarceration. So there's a lot of that rather than having some positive ways and views. So I think that is the situation in Malaysia. I think they always feel that let's follow UK to be safe.
All right, definitely interesting.
I don't know why.
My next question, again, is directed at both of the papers that were presented today. So in both papers, you discussed discretion. And maybe, Rena, I'll start with you this time. So we talked about discretion with policing and with sentencing. And again, a lot to be done here. And still, I think we'll see how it evolves over time. But how do you think AI will impact discretion? Simon, in particular, you mentioned it needs to be bounded and transparent. But as it relates to sentencing first and then coming to policing next, what is the role of AI and discretion as we move forward? Yes, Rena.
The role of AI. I can see, are you asking just for sentencing or anything?
Well, you can speak more broadly for criminal justice.
For criminal justice system, I think, it's great to use AI. It saves a lot of time. It makes manual laborers work easier, A friend of mine, police stations, they were telling me that they have this software that collates data, make it easy for them to locate certain people, check the, records. And in prison, for example, during COVID, where you have to give medicines to the prisoners, they use the robot, they use the machines, which is safer for the inmate itself and the prison guards. In terms of court, I know because of the backlog of practices, to me, it is, I would say that we can use AI, but AI should not be the machine that makes the decision. They can give recommendations, and I think there need to be strong guidelines around using AI and adopting whatever recommendations, because we're just, I think, Simon, you rightly pointed out that cases that are reported are just cases that go for trial, go for appeal. Most of the cases do not go for an appeal. So the law is to cater the masses, not just those who go for appeal. So we don't know what happened to the other cases and those who just blindly and just succumb to the use of AI. So we have to be very careful, and I think always have in mind that AI cannot replace a human being. I think that's that, even if we use that.
Yeah, definitely. There are a lot of people who argue about the importance of the human in the loop. Azrini, did you have something to add? And then we'll come over to Simon or Jose.
Yeah, thank you, Maria. Just to add from Hasrina, we know that currently in Malaysia, only 30% of judges support the AI recommended sentencing decision, which definitely shows a high level of discretion at the moment. And we know that in Dennis P. Maduli versus PP, the judge actually gave a harsher sentence. How long that level of discretion is going to exist and last for as we go forward is questionable.
So it reminds me, I had a PhD student 20 years ago do a study. It was never really published, sadly, looking at grid sentencing and matrix sentencing and comparing it to guideline sentencing. And he was a statistician, so I struggled a bit with the numbers, taking that point about lawyers and numbers. But what he discovered was this interesting phenomenon that the introduction of the grid and the matrix in America was designed to eliminate diversity of outcomes. The fundamental principle, like cases be treated alike. And the media response, it's not fair, this person only got 2 years, this person got 5 years. But of course, as we know, the more context around the individual offending that we put in, instantly people become cognizant of the importance of mitigation and the factors individualised justice, and as was emphasised. And it just showed up, interestingly, that there was actually greater latitude in judges within the grid and the matrix system than there was with the guidelines discretionary model. And that's because any grid essentially allows some degree of flexible margin of appreciation. And you could plot it. So there were some judges that consistently within the grid that they had to decide always went for the most lenient, always went for the harshest. And yet they were sentencing on the grid and the matrix. What was interesting with the ones at large applying the guidelines with just discretion, I think the judges talk to each other, and particularly in our system where there are actually few judges who are engaged in sentencing. They go to conferences, they talk and they share their practice. There's a lot of tacit knowledge. And we also approach it in a black box. We have a black box around sentencing because judges are encouraged in Australia to approach it not in this highly mechanical way, but as an instinctive synthesis of all of the factors to come up with a number. Now that would suggest that there would be a high level of diversity. I think what you would find is, in fact, it would be interesting to do a controlled experiment around, an AI-supported system and judges applying instinctive synthesis, honestly, which obviously is a lot of tacit knowledge that brings about high levels of conformity. And I think that would be quite interesting to think about. But we shouldn't assume always that the use of the technology will produce more consistency. It may actually have the opposite effect. But I think Jose may have some thoughts about discretion, and maybe even to talk about the Ombudsman's recommendations, which I think are very interesting.
So, I'm not an administrative lawyer, which means that every time that we get to administrative law, I need to ask people. And I came up with a very tricky question, apparently, which is, can you please explain to me what discretion actually means in the Australian system? I asked 4 administrative lawyers. I got 4 different answers. So I think we are not very clear what we mean with discretion. But in my limited knowledge, I think we can understand discretion as the boundary for arbitrariness. So the moment you are arbitrary, you are beyond what will be the reasonable discretion that you may have. People may disagree legitimately about how to treat some circumstances. So within that boundary, which is not arbitrary and is legal, that's where discretion plays. And traditionally, we have been saying machines cannot do that. That is left to a human mind because we can analyze the circumstances, we can see the different elements playing around, and with that framework we are better at taking that into consideration, and we're not going to generate some output, some response that is completely absurd, because our intelligence and peer pressure as well is going to put us within those boundaries. Interesting enough, that was the position of the federal ombudsman. And earlier this year, they updated the automated decision-making guidelines, and they created an exception for machines may be able to apply discretion. And it was an acknowledgement that with artificial intelligence systems, that we don't need rules-based system in which A and B gets you to C, that with artificial intelligence systems, with different types of machine learning, we may be able to assess bigger framework of elements in similar ways to human beings are treating complex circumstances. We don't know, but that's the point I would like to. We do not know, and if we start accepting, well, machines have all this giant data set to learn from, so they can apply this element of discretion, for example, in sentencing between this boundary and this boundary, it will be very different from we get a recommendation and then a human tries to see beyond the recommendation. The point is, we do not know about this.
Thank you. I'm going to abstract out a bit and ask us a broad question, and then I'm going to come to Slido because we do have some questions there. So when considering both the challenges and opportunities associated with AI in the criminal justice system, what is the most important factor that should be addressed now to promote transparency and justice? And again, I realize this is a huge question. Azrini, I'm going to start with you. But as we think about this increasingly digitized world, where do we start to promote transparency and justice as we start to integrate technologies, especially AI, into the criminal justice system?
I think that's a great question. And at the heart of the deployment of AI has to be ethics, justice, due process. And as we know with any new technology, the development of AI in the criminal justice system has absolutely tremendous potential, which must be considered against an acknowledgement of the accompanying risks and the possibilities of those risks and that impact of those risks on human rights. As we know, artificial intelligence becomes more embedded in the criminal justice system as we progress through time, from predictive policing, surveillance tools, pre-trial risk assessments tools, sentencing, prison management, parole decisions. And for me, the challenge is not merely technological, but ethical and institutional. I completely believe that without clear guidelines of accountability, it becomes impossible to ensure that AI systems are transparent, fair and just. The opportunity in promoting justice lies in using AI to enhance justice, not to automate existing biases. We need to consider, and we've spoken, both speakers have talked about or alluded to the black box and the current lack of transparency in design and in decision making. There has to be guardrails for the design, development and deployment of AI in high risk settings. There is currently a lack of oversight and accountability. So we do need independent mechanisms to review, contest and correct AI-driven decisions. Statutory guidance on AI use in the criminal justice system, such as the European Ethical Charter on the use of AI in judicial systems, or the Malaysian AI governance and accountability framework, are moves in the right direction. But we still have a long way to go. Hannah Moffat in her work argues that AI is time efficient, less costly, provides consistency. But going back to what you said, what does it mean to be consistent when we know that the risk predictive tool such as Compass, for example, discriminates against young Afro-American males at least twice the rate. It's owned by a private company, and that brings into question, should justice, such as the deployment of a predictive tool like Compass, be owned by a private company which serves for one purpose only, and that is profit. A wonderful article written by Carolyn McKay states that criminal justice is a human institution, and thus AI as a tool is to make recommendations. It shouldn't supplant judges' discretion. And in looking at the literature and how we're moving in terms of the fourth revolution and the quantum leaps AI is making in every aspect of our lives, AI in sentencing, AI in the criminal justice system cannot be denied its rightful place to realise its full potential, whereby the machine learns and improves as it synthesises new data to create sophisticated neural nets and deep learning. That doesn't really answer your question, but it does demonstrate the complex nature of the discussion in play.
Thank you. Yeah, Jose.
Can I react to that? Sorry, I'm smiling because I just had this conversation again today. I'm a bit countercultural in this space, so please bear with me for
It's great for a panel.
2 minutes. About 3 years ago, we were writing, as the University of Sydney, a reply to one paper from the government that wanted to establish some kind of guardrails, the previous government, so 4 years ago, for AI. And everybody was saying, like all the tables, transparency, yes, transparency. And I said, transparency for what? Transparency for the sake of transparency will not get us anywhere. And I went to Parliament in New South Wales. I was providing a witness statement, and I was telling the parliamentarians there, the MPs there, look, you land at Sydney Airport, you show your passport, then you cross, and then if you get to the wrong line or the right line, depending on how you go, you end up in front of a machine that is not going to give you any kind of explanation of why it barks or it doesn't bark. It's going to lead a human to make a decision, which is going to be to search your bag or not search your bag. And that machine is the dog that we have been using, sniffing dogs, which apparently they are regulated in New South Wales in quite a bit of detail. And we are not asking the dog to give us explanations. What matters for us is the accuracy of what we are using and what the human that is using the dog is going to decide on that basis. What is the problem? That there, it's quite easy to assess that in terms of accuracy. You are finding the drugs or finding the type of seed that you were not to import in Australia, and it's quite easy. The problem when you move to the criminal justice system is that we don't have that kind of a standard of accuracy that clear. Is this the right decision or not? And that's why transparency makes sense, or explainability, or whatever you want to call it, in the way that this decision, I would like to know more about how the machine made this decision, because may not be the one that we as a society accept as accurate or good or acceptable, whatever it is. But therefore, many other decisions that everything we care about are they accurate? Is this giving the right answer, yes or no? And what are we going to make on the basis of this recommendation or this output? So, transparency, if it's not binary, it's not yes or no. It is for what purpose do you want it? Because by itself, well, it's not necessarily, I'm not an expert. If they give me all the data set or all the training or all the way the algorithm was designed for something, it's not going to help me much. But I do care what that generates in terms of output a lot. So that's...
That is an interesting take. Look, we could spend a whole nother hour digging into that one deeper. And maybe we will over the reception. Yes, we'll take one more. Okay. And then I'll get to our Slido question, and that'll wrap us up and head us into the reception. Yes, Rena.
Yeah, I'm just thinking if I'm being charged with an offense, and or you ask anyone who is in prison or anything, like, how were you sentenced? And you say that there's an AI automated machine giving that recommendation for me to be sentenced. How would that, how would I feel if, let's say, I'm being charged? How would that person feel? Like, you're not being judged by a real judge, and even if there's real judge or magistrate in front of you, that person is being advised by a machine. You see, so while we are talking here how great this AI can do and everything, but from the lens of a person who's being charged, from the lens of a person who is going to be sentenced, they don't see those things. What they see is just that magistrate, and then whatever being keyed in, there's some report that comes out, and there you go. Okay? So to me, that comes to transparency. That's the whole thing about transparency. Did that person even consent for that kind of system to be done? I go to court with the intention of getting justice, but I get the justice from a robot who is actually advising the magistrate. So I think that's why I think that the lawyers are very concerned, because they do not know for sure how it works. And I think that their concerns are legitimate.
Yeah, thank you. Okay, so that's going to take us to our last question. It is from Slido. Simon, I'm going to start this one with you and then open it up, potentially. Okay, so my research is on AI literacy among medical doctors, which can be related to lawyers, judges, or police. What AI responsive pedagogy updates or reforms do you think should be integrated into the current legal and criminal justice education? And I like this question as our final because it integrates concerns from a researcher about education and how we move forward.
Well, there's a lot of attention in the profession. There's a lot of anxiety that the legal profession is leaping in, perhaps a little bit too enthusiastically, not appreciating limitations around many of the systems, and that it's generating these cases where judges are discovering that the cases are made up, or if they're not made up, they're completely irrelevant to the proposition. And so that's leading to some kind of cautionary tales from the bench about professional misconduct. I do think that's a temporary problem as the systems become better and they're better trained. And you can see exponential leaps forward on that. I think the key thing is encouraging people to disclose. Even we have some research suggesting that even when we tell students that they can use it and they should disclose, they continue not to disclose when there would be no consequence if they do disclose, because they feel that somehow it is an element of illegitimacy around the use of AI. So it's like anything. I think we're in a bit of a transition where the university itself is, trying to develop new norms around it. Authenticity is really what we're trying to, and integrity is what we're trying to cultivate. So I think the technology is here to stay, and it has to be embedded, a bit like First Nations knowledge and cultural competence and good legal research skills, which I think are one of the dangers is that students may learn not how to read a case or analyse a statute because they'll be leaving it to the technology, which will become more reliable. And I think that's, it's a useful tool. It's a dangerous master, I would potentially say, but it's here to stay.
Definitely. Look, I think that's the perfect way to wrap up. So please join me in thanking our panelists and presenters. Thank you to all of you who've joined online and submitted your Slido questions. Thank you to those of you who are here with us. We have a reception with food out there waiting. Those of you online, you will be missed. We'll make sure we have something for you. So thank you, and please join us as we continue the discussion.